Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3011, United States of America versus James Little, appellant. Mr. Carpenter for the appellant, Mr. Dushevsky for the appellate.
Mr. Carpenter.
May it please the court. We are asking this court to find that the district court violated double jeopardy by increasing Mr. Little's prison sentence for a petty offense from 2 months to 5 months after his successful appeal in this court. We believe that action violated double jeopardy for 2 independent reasons. The first is that the Bradley rule has direct application in this case because probation and imprisonment are sentences of a different type. Second is that even if the Bradley rule did not apply, Mr. Little had a legitimate expectation of finality under this court's decision in Folk.
Why would we say that probation and prison are a different type, but not say that probation and a fine are a different type?
So
Bradley was a fine.
Correct. I think all 3 of those are different types of imprisonment. And I think the easiest, aside from Supreme Court precedent, the easiest way to see that probation and imprisonment are different types of punishment is to look at what the district court did in this case. Because rather than provide credit for the entire time spent on probation, the court used a formula of 18-1. Our fundamental point is this: if you need a mathematical formula to convert one thing into another thing, then those 2 things are by definition not the same.
So according to you, no formula would have been good enough. It couldn't be 2-1 or 3-1. No formula was good enough.
Correct, Your Honor. Our view is that under double jeopardy principles, under the reading of Bradley that the Supreme Court adopted in Jones, if the sentences are of a different type than the Bradley rule controls, that means that the completion of one of the 2 alternative sentences originally imposed forecloses the enforcement.
You feel like you preserved an argument in the alternative? Let's say we do think that some formula was appropriate, but let's say we think 18-1 was too high. You haven't put all your eggs in that other basket?
That's correct. We do have the backup argument that we feel like we preserved both by making the overarching argument and by specifically objecting to the formula at the sentencing hearing itself.
What formula did you propose a formula at the district court?
We did not propose our own formula because, again, our view was no formula. Our backup
So assume we think that there should have been a formula and that 18-1 was too high. How would we go about figuring out what the formula should be?
So I think the fact that it's so hard to go about that would indicate our first argument. But walking into the second argument, I think you would have, this is where it gets arbitrary. And this is why I think this Iowa Supreme Court in Jepson had the best of the analysis saying that it's arbitrary, right?
Okay, I understand. So how was his liberty restrained when he was on probation? I understand how it was supposed to be restrained, but
Certainly.
what did he actually not do that he would have done absent probation?
Certainly. So I think there are lots of restraints on a probationary period that people don't necessarily think about. So for example, it is, I think, quite a large infringement on anyone's liberty and dignity to be obliged to pee in a cup upon the request of the probation officer. He was subject to drug testing. So that's one.
You're not saying he would have used drugs absent probation?
No, but I'm saying as someone's
So
liberty.
aside from the monitoring, what did he want to do on probation that he didn't get to do?
So I think that what he had to do was to report to his probation officer anytime he wanted to go out of the district. He had
That is not a very great restriction. Maybe it is a restriction on liberty, maybe an 18-1 equivalent restriction on liberty, but to say he could basically do everything he wanted as if he was not on probation, he just had to be monitored.
So I think he also could not exercise his Second Amendment rights, which is a substantial one. He had a gun restriction that will not apply to him going forward because he is not a felon. What's that?
Did he own a gun before all this?
Yes. I mean, in North Carolina, virtually everybody owns guns. Yes.
So on probation, he had to give up the gun? He would like give it away or what?
Yes. I don't remember the details. I remember there was an objection in the district court to the firearm restriction. that was overruled at the initial sentencing by Judge Lamberth. I don't remember the exact details of whether it was transferred custody or what exactly. I do know that he was not allowed to exercise his Second Amendment rights. His First Amendment rights were also restricted, which was,
Let me ask a more legal question as opposed to the fact specific to this case. Can you think of a precedent where the court found a double jeopardy violation? The new sentence did not exceed the statutory max when combined with the old sentence. And the original sentence did not come with an expectation of finality. So there's 3 boxes to check here.
Okay.
Double jeopardy violation. The 2 sentences combined do not take the defendant beyond the statutory max. And the original sentence did not have an expectation of finality. Can you think of any case that checks those 3 boxes?
I don't think I can. I think the thing I would say about the reason this case does not, at least in our view, fit in the second box is it's premised on the assumption that he does not get full credit for the probationary time, because the 18 months that he spent on probation, of course, if it's credited, then it's well beyond the statutory maximum for imprisonment. I think the other reason that second box isn't checked in this particular case is the dual sentence that he served, the 2 months plus 18 months on probation, is a sentence that is not authorized by the legislature. There's no doubt he could not have been required to serve that. So it's something that is unauthorized by the legislature. And we think for that reason, it is different as well. I would also contend that on the third point, there is an expectation of finality in the prison sentence here under Fogel, because the defect that he challenged on appeal was unrelated to the length of imprisonment, just as the defect in Fogel was unrelated to the length.
I get that, but it does seem awfully strange to say that he had an expectation of finality in a sentence that he had challenged as illegal.
Well, again, and I think I acknowledge intuitively that does seem a little strange, but I think it is consistent with this court's decision in Fogel because the challenge was unrelated to the length. I think
Isn't Fogel different? Because in Fogel, the court changed the sentence sua sponte. Here, your client appealed the sentence. How can he have an expectation of finality in something he appealed? He wanted it changed.
so. I acknowledge the factual difference there, but I think it's a bit perverse, as we said in the reply brief, that we would punish someone for raising the illegality as opposed to in Fogel, where the
It's
district
about
court
his-
happened to realize
It's about his expectation. So that's why Fogel is really not on point.
It is, but that's true. I think Fogel is on point, though, because the question under Fogel is, could the defect have been cured without, in the sentence brought into compliance with the statute without raising the prison sentence? And that was just as possible here as it was in Fogel. So I think his expectation is that if he was correct on the appeal.
I just think when you're focusing on the defendant's expectation and the defendant has put the sentence into question, it's difficult to say that he had an expectation of finality. But in terms of your argument, you're relying on Bradley.
Yes.
But the Supreme Court said in Jones that we do not think the law compels application of Bradley beyond its facts. It basically cabined Bradley to its facts. And the facts here are very different because in Bradley, you could not credit a fine against the term of imprisonment. But here we're talking about probation, and there are other courts that have credited probation and supervised release, things of that nature, against imprisonment. And if you can credit the alternative sentence, then ultimately the final sentence, if it credits, what had gone on before, there's no violation of double jeopardy. That seems to be what Jones says.
Yeah, so I think there are 2 points where I would dispute there. The first is that in Jones, I think what it says is that the line of reasoning in Jones is that Bradley continues to apply where the sentences are of a different type. That means we're back to the question of our probation and imprisonment sentences of a different
But it's
type.
confined to its facts, and that was a fine, and this is probation.
Well, again, I think the reasoning line, though, was the reason that Bradley does not apply here is because the sentences there were of a different type. I think the second reason that I would push back on the way you articulated it is that it is absolutely possible to use a mathematical formula to convert a fine into imprisonment. You could say 1 day in prison equals 100 or 500 or 1,000
It's
or whatever.
possible, but the Supreme Court has said you can't.
Right, and I
The
think
Supreme Court has not said that you can't credit probation.
But I think the logic is what follows through, which is that if you need a
We're
formula.
not writing on a clean slate. Supreme Court has held that already. Supreme Court says you can't credit fines against imprisonment. Supreme Court has not held that you can't credit probation against imprisonment. And we've got courts in different jurisdictions that have credited probation against imprisonment.
Well, they have, but I would highlight that it's in a very different context. This is, I acknowledge, a question of first impression in terms of whether you can evade the double jeopardy rule in Bradley by crediting under a ratio like this. The decisions that the government relies on are almost entirely under the mandatory guidelines where there's a government appeal. If you look, Miller, Carpenter, Martin, those are cases that are all specific to that context. And in that context, the double jeopardy question is fully asked and answered by the Supreme Court's decision in
I
DeFrancesco.
understand those are not double jeopardy cases, but they address crediting probation against imprisonment, and that they've done that. And I think you need to meet a plain error standard of review because you never objected to crediting probation against imprisonment in the court below. And given that other courts have done this, you can't meet a plain error standard of review.
So I think there's 2 points there. The first is that the question those courts were asking and answering about crediting was not a double jeopardy question, as you acknowledge. It was solely, may a court depart? Does it have permission to depart under the mandatory guidelines to account for this?
Right, and nobody's citing those cases for anything having to do with the guidelines or double jeopardy. Those cases are cited for the proposition that you can credit probation against imprisonment. And that's what the court did in this case. And you did not object that is not something that can be done.
Well, so again, I disagree with that. For the reasons we set out in the reply brief, we think we absolutely preserved the objection that crediting was impermissible because
What's your best argument that you preserve that? Because I saw that you did a block quote that mentions crediting, but you never put before the district court the argument that you cannot do this.
So our 2 arguments, I guess. The first is that under our primary argument below is that these are sentences of a different type that cannot be credited against each other. That was the entire through line.
You didn't say that cannot be credited.
Well, I believe we quoted that exact line in Bradley.
Right, you did a block quote from the Bradley, but you never argued to the district court that your position before it was that it is impermissible to credit probation against imprisonment. So the district court couldn't rule on that. You didn't put it before the court.
So again, I think I just disagree with that reading of the record. But the second argument would be, even if we should have been more specific there, this is a double jeopardy claim that under Yee versus City of Escondido is preserved. The argument about crediting is simply a different theory in support of that same double jeopardy claim. There's, I think, no dispute that we preserved a double jeopardy claim below. All we're talking about is the arguments in support of it. And so I think under Yee versus Escondido.
Is that how issue preservation works? Do you have any authority for that? Just because you made a double jeopardy claim writ large, every argument is preserved?
Yes, Your Honor. The primary authority for that is Yee versus City of Escondido for the Supreme Court, which this court has cited in Woodruff and other cases for that exact principle. And so if you look at Yee itself, that was a case where a takings claim was preserved. It was argued below solely on a theory of physical occupation. By the time it was appealed up to the circuit court and then to the Supreme Court, the theory that was addressed by the Supreme Court was entirely different from physical occupation. It was a regulatory takings theory. So we believe under Yee, the claim is fully preserved.
You talked about how he had to report if he wanted to travel. I think you mentioned
yes.
That. Do you know if he would have traveled?
I know that his previous job had been required him to travel out of state, and at least for a time period, he didn't undertake that job, and he eventually did, but then had to get permission with each work trip. So
he did travel across state lines and while he was on probation, and he got permission when he did it.
My understanding is that yes, he did travel sometimes. I can't say that. I believe so for work. I will say that the facts of that, whether he was denied at any point or not, in the record, and I don't represent that I know.
My last question, and then I'll see if either of my colleagues have either questions. Is I think you wrote a very good brief. I think the government wrote a very good brief. I have a quibble with both of them, and I'll ask the government as well. It's probably more quibble with the government than with yours, because you do say you think Bradley is just completely controlling. And if you're right on that, then we're bound by Bradley. But if there's not a directly on point precedent, I would want to know what the original meaning of the double jeopardy clause is. And I'd want that original meaning applied to the facts of this case. I try to figure out what the original meaning is and apply it to the facts of this case. There's not very much argument about original meaning in your brief. I understand not all judges think original meaning is as important as some other judges do, but
Sure.
If I feel like I need that and it's not there, what do you propose I do?
Sure. So, I mean, I think original meaning, actually, I mean, maybe this is a cop-out, but I do think original meaning accords with the Bradley rule, because I think original meaning of the double jeopardy clause in the multiple punishment context is just that. You cannot suffer multiple punishments.
Bradley is about, 5 minutes long and
Well,
doesn't even mention the double jeopardy clause. Never mind analyze what double jeopardy meant at the time of the founding.
No, fair enough. And I guess we would go to Lang before that. But if you look at the rest of the cases that have gone into more detail over time about the various applications of the double jeopardy clause, I think the piece of it that is helpful to us is that what the double jeopardy clause prohibits is being punished twice for the same offense. As applied to this case, the legislature said you can be punished once, either A or B. He undoubtedly was punished with both A and B.
Doesn't original meaning contemplate the possibility that if there was a mistake and there's an objection, the case can be sent back for resentencing? And the resentencing can look different than it originally did? That's not inconsistent with original meaning as I understand it. That's always been a possibility.
I think that is true, but I think
this case would fit within that frame.
I think the reason that it doesn't, Your Honor, is that what you cannot undo is the 18 months that he served on probation. That time, it's different than a fine, which can be refunded. But even the Supreme Court in Bradley said we can't do that. The 18 months that he served can't be magically given back to him. He can't go relive those 18
You're
months.
just fighting the crediting. That's your crediting argument.
I agree with you.
You certainly can have resentencing and it can end up looking different.
Oh, absolutely.
And that's not a double jeopardy issue.
No, and that's clear under the sentencing package cases. And the reason they're different in this case is, I think, twofold. First is that those cases, by definition, involve multiple counts of conviction, which put them with multiple sentences of imprisonment, which put them within the Jones rule directly. So that's one difference. And the second difference has eluded me. So but that is the key difference that I will stick with.
Okay, I'm done. Thank you.
Thank you very much. We'll give you 2 minutes of rebuttal.
Good morning, and may it please the court. Ruvain Deshevsky for the United States. The sentence imposed by the district court on remand does not violate double jeopardy. It credits all time previously served by Little in prison and on probation. It imposes a sentence, a total aggregate punishment within the maximum authorized by statute, and Little could have no legitimate expectation in the finality of the original unlawful split sentence that he successfully challenged in his first appeal. In the second appeal, his claim relies entirely on Lang and Bradley, but as pointed out by the court, the Supreme Court's more recent double jeopardy decisions limit the precedential value of Lang and Bradley to their specific factual contexts. And what we have here is different. Most importantly is this crediting issue. As opposed to the fine and prison in Lang and Bradley, what we're dealing with here is probation and prison. It should be uncontroversial that probation, time served on probation, can be credited against a future term of imprisonment. Little has not identified a single case that holds otherwise. And in fact, the cases cited by the parties in both briefs overwhelmingly approve of crediting of probation against prison.
Let me ask you a follow-up to my last question to Mr. Little's attorney. Imagine that there were no precedents related in any way to this case for the past 200 years. And I think you would still have the argument that Judge Edwards mentioned, that as an original matter, it was fine to resentence after an appeal, after an appeal vacates the original sentence. But of course, this case has some complications that a typical resentencing doesn't, including the crediting factor. Well, you have no precedent. Imagine there's no precedence from the past 200 years. What would your argument today be?
I think that the crediting solves that, but also, and not to fight back against the hypothetical.
They're crediting
but
the
the-
founding?
Well, I'm sorry.
I mean, there were so many kinds of different ways of punishing of the founding that are different than now. So I'm not faulting you if there's not, if you haven't found an instance of this kind of crediting at the founding, but my impression is that you have not.
Well, I would say two things. First of all, probation wasn't a sentence at the founding. Probation only became a sentence after the 1984 Sentencing Reform Act. The second thing I would say, and I realize this is pushing back against the hypothetical, is that the Supreme Court has told us what the double jeopardy clause means. And so I don't know that it's necessary to engage in any sort of exercise to try to determine what it meant at the founding, because the Supreme Court has told us in DeFrancesco and in Jones that in the multiple punishment context, the interest that the double jeopardy protects is that a defendant not suffer greater punishment than that authorized by statute. And what we know from North Carolina v. Pierce is that crediting protects that interest.
I think even you don't think that's the only obstacle to the government winning here. I take your brief to say it has to not exceed the statutory maximum of punishment, and there has to have not been an expectation of finality at the sentence.
Absolutely. Yes, both of those interests exist.
And that might be a great test, and it may be the test we apply, and it may be the test that is compelled or at least suggested by the best reading of the precedents. But this just strikes me as a case where if I agree with you and Bradley is not directly on point and controlling, then there's not a case that's directly on point and controlling, in which case I wish there were more argument about I wish there were more briefing about the original meaning of the Constitution.
I understand that, and at the same time, again, the Supreme Court has told us that these two interests are are the interests at play in the multiple punishment context. And while this court is writing on a blank slate with regard to crediting probation against prison, as Judge Pan pointed out before, there are many other courts that have addressed this issue. And I would disagree with my opponent that a number of them do address it in the double jeopardy context. Not that that matters, because the point in the end of the day is that if probation can be credited against a future term of imprisonment, that is more than enough to distinguish it from Bradley and put us in a place where Mr. Little's double jeopardy rights have been protected.
So to follow along with this idea that we should look to first principles of double jeopardy clause, you can't be put in jeopardy for life or limb, I guess, for the same offense. And it seems to me that when there's an appeal and a remand for resentencing, it is one punishment for one offense, and it's just being corrected. And as long as you're not going above the statutory maximum, you're not violating double jeopardy. And in this case, the argument is that these are two punishments because you've already served one part of the original sentence that was imposed. But the response to that is it's not two sentences, it's one sentence, because you can credit what you served before to what we're doing now. So it's all one sentence. And so that is consistent with the original meaning of double jeopardy. It is one sentence for one offense.
I think that's right. And I also think that goes to another point, which is that Judge Lamberth crafted a single sentence in the split sentence the first time around. And he provided his reasoning in his written opinion for that. And it was intended to exact a cumulative punitive effect. And when this court's decision in the first little appeal unraveled that sentence, what Judge Lamberth did on remand was engage with that cumulative punitive effect and try to craft a sentence that both protected Little's double jeopardy rights, but also achieved what his responsibility was under the 3553A factors. And so crediting protects the double jeopardy rights. And I just like to turn quickly to the expectation of.
Can you respond to your friend in the other side's question, argument that his crediting argument is preserved because anything that supports a double jeopardy claim is preserved?
Yeah, so I agree with the thrust of the question that you asked him, and I would distinguish Yi. I don't think that raising a double jeopardy claim writ large preserves every possible claim that falls within double jeopardy. And one example where the court has dealt with this issue recently in a different context is United States v. Stevens, which dealt with the aggravated assault guideline, where the defendant below challenged one element of the guidelines definition, and then on appeal added in a second challenge to another element of the guideline. And what this court found in Stevens, which was an opinion issued earlier this year, is that making one of those claims does not preserve the other, even though arguably, because he made the overarching claim attacking the application of that guideline, that everything else would fall within. And I think that's the same argument that Little is making here with regard to plain error.
Are you aware of Yi being applied in any criminal case in this circuit to preserve claims like this?
I'm not aware. I don't know.
Thank you.
With regard to the legitimate expectation of finality, I think this court's case law is clear, including in Fogel, that a defendant that successfully challenges an unlawful sentence does not have legitimate expectation of finality. The unlawfulness of the split sentence is not similar to the quote unquote technical defect involved in the Fogel case. As the court pointed out, in Fogel, the court acted sua sponte, which casts it in a different situation than here.
Tell me, play it out a little bit for me. I'm not sure I understand how you're addressing Yi, which says, once a federal claim is properly presented, a party can make any argument in support of that claim. Parties are not limited to the precise arguments they made below. How does that work? How does that work for you?
So what I would say is making a claim of double jeopardy does not open up the whole universe of any subclaim within double jeopardy. And so what Little did not do below is he did not challenge the imposition of a new sentence because probation cannot be credited against prison. He did not challenge the imposition of a new sentence because a 1-to-1 crediting ratio, if probation and prison can be credited against each other, if that a 1-to-1 ratio was required. He didn't make those claims. And so what I'm saying, and one example again is US v. Stevens, which is a criminal case, which distinguished E. Making a general attack of one sort doesn't necessarily mean that all subsidiary claims or possible subsidiary claims should be included in that.
You're saying the claim can't be double jeopardy. It has to be the crediting. And any argument in support of that.
To preserve it. And I think that
I'm just trying to see how you're breaking it down in your head. You can't just say, well, there's double jeopardy violation. Or to be silly, I was treated badly, and now when I get on appeal, I can say anything I can think of in support of that. I was treated badly. You're saying the claim has to be the crediting.
I think that's right. I think that's right. And regardless of whether the court agrees or not, the government is comfortable with its crediting position on the merits. So I don't think that whether or not this is plain error should affect the outcome of the case here.
So in Stevens actually did rely on Yi to make new arguments in support of a preserved claim. And I guess this court rejected that, saying that these are not, that Yi didn't apply because they're not two separate arguments of a single claim. These were separate claims.
That's correct.
And I guess in this case, the analysis would be saying that the alternative sentencing cases applies to preclude this is different from saying, it's a different claim from saying it is not possible to credit probation against imprisonment. That's a different claim.
That's right.
It's a different type of double jeopardy claim.
Right. And when given the opportunity to object at the end, after sentencing, Little said, you know, I don't really like this ratio. I think a 1-to-5 ratio would be better. But nowhere in the briefing before or afterwards did he make a claim that double jeopardy prohibits that sort of crediting, or that double jeopardy requires a 1-to-1 offset. If the court has no further questions, we'd ask that the judgment below be affirmed.
Thank you.
I'll begin with the second reason that eluded me before, if that's okay. The second difference in the sentencing package cases is the expectation of finality. And that's where we think, again, it's critical that the defect here was unrelated to the length of imprisonment, which distinguishes the situation from the sentencing package cases. I think the other key component of the expectation of finality here is the lack of a cross appeal. If you look at what the Supreme Court has said in Greenlaw, it says that when the government is seeking to increase the length of a sentence, it needs to file the cross appeal, because that gives the defendant fair warning that pursuing the appeal could subject him to additional
I'm sorry, what would
imprisonment.
the cross appeal be in a criminal case like this?
So the cross appeal would be that if the government could have cross appealed and said 2 months is not a sufficient sentence under the 3553A factors, which is apparently what Judge Lamberth concluded on remand by increasing it from 2 months to 5 months. So the government could have filed a cross appeal arguing that Judge Lamberth had made a mistake under the 3553A factors in imposing a sentence that lenient. Doing that would have
I'm
given.
sorry, so are you suggesting that for us to remand a case for resentencing, we can only do that if the government cross appeals?
If the challenge is unrelated to the length of imprisonment. Certainly if there is in the normal case that you deal with the challenges to the calculation of the guidelines or the procedural reasonableness of the sentence, all of those we acknowledge clearly covered by the expectation of finality precedent, that by putting the length of the sentence in question, there is no expectation of finality.
There are plenty of cases that don't go to the length of the sentence, like maybe you didn't cover the immigration implications of a plea, something of that nature, or whatever, but anytime we remand for resentencing, we can only do so if there's been a cross appeal by the government.
No, it's not that broad. It's when the appeal is unrelated to the length of the sentence. So for example, if a defendant appealed in a criminal case solely based on a restitution order or a forfeiture order and prevailed on that, and the court remanded to deal with those issues, that would not authorize the district court.
Do you have any authority for this theory that the only time we can remand for resentencing, if it's not related to the length of the sentence, there has to be a cross appeal by the government?
Your Honor, the case we rely on that is Fogel, which says that there is an expectation of finality where the defect in the sentence
Procedurally, Fogel does not follow the fact pattern that you
absolutely.
suggested.
It is. We think the principle applied in Fogel would extend here, and especially when read in light.
And doesn't that
of
create
Greenlaw.
incentive for the government to cross appeal things that they don't even think might be meritorious because they want to be able to get a resentencing?
I mean, it does. I think that is a natural consequence of Greenlaw, but I think it's critical in understanding expectation of finality, because I think the key point I would make is there's no doubt in terms of expectation of finality that Mr. Little would not have appealed this sentence had he believed that there was the possibility of an increased prison sentence on remand. So subjectively, there's no doubt there was an expectation of finality here. It's just a question of whether it's one that the court is willing to recognize under its precedent.
So you say that again, he wouldn't have appealed what?
Your Honor, I think Mr. Little is very clear that had he known that the consequence of succeeding on appeal was that he would have to go back to prison, he would have just said, I'll let the error stand.
What if he knew what if he knew that if he succeeded on his appeal, he might end up worse and he might end up better? In that case, he might have rolled the dice.
He might have, and again, that's what the cross appeal would have done. It would have given him fair warning that there was a chance this could get worse. As it was, his expectation
Shouldn't his attorneys have informed him of the sentencing packaging cases that say that if you succeed on your criminal appeal, you could get
That is
the-
certainly a claim he will make in a 2255, I expect. If there are no further questions, Your Honor, thank you.
Thank you.
Case number 23-1166 et al. Environmental Defense Fund Petitioner versus Environmental Protection Agency and Michael Reagan, Administrator of the United States Environmental Protection Agency. Ms. Lisco for the petitioner Environmental Defense Fund, Mr. Chung for the petitioners American Chemistry Council et al., Mr. Dupre for the respondents, Mr. Chung for the intervenor.
Ms. Lisco.
Good morning, and may it please the court, I'm Samantha Lisco on behalf of Petitioner Environmental Defense Fund. For decades after the Toxic Substances Control Act was passed, vast amounts of information that was submitted to EPA about chemicals made in this country was kept confidential with no substantiation for why the information should qualify as confidential and with no review by EPA of whether the information should be kept from the public. When Congress reformed TSCA in 2016, many of the significant changes were aimed at fixing these problems and facilitating public access to chemical information. Among the key reforms, Congress mandated that EPA review companies' confidentiality claims and make affirmative decisions about whether the information claimed as confidential should be confidential or public. Congress also reiterated its longstanding commitment to non-secrecy for health and safety information. Instead of embracing Congress's move in 2016 to more transparency, EPA has issued a rule erecting numerous barriers to public access that are contrary to the statute. First, health and safety studies. EPA itself states that Congress excluded any health and safety study from the information that may be claimed as confidential business information. Indeed, health and safety studies under TSCA are categorically non-confidential, subject to two specific exceptions described in the statute, which is for information that would reveal a chemical's manufacturing process or mixture proportions. Even where companies might have a proprietary interest in blocking disclosure of information in the studies, Congress said no. It said no when TSCA was created, and the legislature repeated its refusal to allow secrecy for health and safety studies when it amended the statute. Specifically, the statute says that both any health and safety study, along with any information reported to or otherwise obtained by EPA from a health and safety study, is per se confidential. That's 2613B2, A and B. In turn, the statutory definition of health and safety study embraces all information in and from a study. With this rule, EPA has now substantially qualified this. While acknowledging that health and safety studies are not confidential, EPA has nevertheless carved out numerous categories of information for confidentiality.
So it seems to me the question is whether some of these carve-outs actually are part of the study. And it seems to me that the way the statute talks about studies is they're really focused on the analysis that supports, the scientific discussion of the chemicals, and not things like the identity of the lab, the marketing costs, things of that nature. And so I think what this boils down to is that information part of a study? And it seems to me that EPA's interpretation seems consistent with the way the statute talks about what a study is.
I would draw your attention, Your Honor, to 2613B2, because there you have A, subpart A. You have any health and safety study which is submitted under this act. And then you have subpart B, which is also non-confidential, which is any information reported to or otherwise obtained by the administrator from a health and safety study.
But it has to relate to a chemical substance or mixture. That's the point. Like, does like the identity of the lab or product code numbers, things of that nature, relate to the chemical substance or mixture?
With respect to modifies study, so what we believe that is simply, it's specifying that the study is one of chemical effects. So an example, there could be health and safety studies about the effects of social media on the mental health of adolescents. That would not be a health and safety study that is in the purview of TSCA. But when the health and safety study is in the purview of TSCA, and any health and safety study about the effects of these chemicals on health or the environment then the entire study is in the definition.
But why? But why? Why does it include things that are not related to the actual chemical or mixture
Well,
when the statute seems to focus on that? And on top of that, this seems to be a practice that is consistent with the agency's practice since 1983. And so I'm wondering, why doesn't this deserve skid more respect, the way the agency has interpreted this?
Your Honor, I would start off by saying that this, statute in our view is very clear, and the fact that they've been practicing carve-outs does not make a regulation.
But why is it clear? Because they're defining study as the actual analysis or things that are related to the mixture, and that seems to be consistent with the statute. So how is it clear that the entire document is the study as opposed to the actual study of the information?
If I would turn to 26028, which is the definition, and it says any study, and it modifies it to explain that it's about chemical effects, and it includes underlying information. I'll take an example.
Underlying information is about the analysis of the chemical or mixture.
Underlying information is included, but health and safety study is an independent requirement. So the health and safety study is mandated, in our view, under
Everybody
26028.
agrees about that. The question is just what's included in the health and safety study. And you pointed me to a definition that doesn't seem to support your definition.
I'll give examples of, if you look at the carve-outs that EPA has created from they've now redefined health and safety study. They talk about carving out information about the laboratory who's performing the study, their affiliation or sponsorship, funding by the company whose chemical is being studied. And so that's the sort of information that is very much part of a study. It will be, and is...
Well, okay. It seems to me that even if that's a carve out, they would have to substantiate and assert that if they want to keep it confidential. So it's not like they're saying all lab companies and identities and all of this will always be kept confidential.
In fact, Your Honor, that is one of our real concerns about 703.3 is that no, it does not by its terms require any sort of claim. This carve out actually under our reading permits a company to redact that information, any information that it sees as relevant to the 1, 2, 3, 4 subpart carve outs, and submit it to EPA with no claim and then no substantiation by EPA and no review by EPA.
Why is that so? Because if the statute says this is not subject to confidentiality, right? So the actual study or mixtures under their reading studies concerning the mixtures and the chemicals would not be subject to disclosure. But things that are not part of that would still, if you want to keep it confidential, you would have to substantiate and claim it.
I think the mechanism, the way that we see it, the mechanism by which they did this, they redefined health and safety study provides the ability for companies to circumvent that process that TSCA section 142613 mandates. So here they've redefined it. They don't say at the end of 40 CFR 703.3, and you must claim we will substantiate, or you will substantiate, and we will review and make sure what you've claimed
But if
is.
it's not subject to that provision, then isn't it with all the other information that you have to substantiate? Isn't the default that if it's not subject to this confidentiality provision, that the default is you would have to assert and substantiate if you want to
I
keep it
think-
confidential?
I would say in general, that would be our, desire, that the default should be claiming, certifying, substantiating, and EPA reviewing. But here, EPA was very clear. Listen, we agree the health and safety study is sacrosanct, but what we're just saying is we're redefining health and safety study, and that's what they do in 703.3. And in our view, there is.
Okay, first of all, is it a redefining if it's consistent with their practice since 1983? And given that only the health and safety study, as they define it, is subject to this confidentiality, anything that's not part of it, which is the stuff that you wish were, they would have to be asserted and substantiated to be kept confidential.
Your Honor, something that I think is really important to remind ourselves is that Congress amended the statute in 2016, and it amended it to re-up this very clear, in our view, prohibition on confidentiality for health and safety studies. If they had wanted to add exceptions or redefine health and safety study, they could have done so, and they did not.
They're presumed to legislate knowing what the current landscape is, and the current landscape is consistent with what the agency did.
Well,
So-
I would say not all of these carve-outs were actually in effect at the time. Some of them have been added, and the EPA did it alluded to a legislative statement
So
about.
40 CFR 716 from 1983 says that information in a study, such as a company name or address, financial statistics, or product codes used by a company, which is irrelevant to any health or environmental effect of a chemical, may be claimed confidential.
We also have laboratory information, identity of the laboratory. We have subpart 4, which is information pertaining to marketing plans, et cetera, which we explained in our briefs that some of that information is relevant to understanding how a chemical might be used and therefore how people may be exposed.
Right. So they would have to substantiate that. If they
We
wanted to keep it
don't,
confidential.
we fear that they would not have to.
Okay.
Can I ask you a question about issue 2? In the Chemistry Council's intervenor brief, page 17, they say the following, and I'm wondering if you agree. The pre-commercialization claim lasts only until the filing of a notice of commencement, at which point a CBI claim for chemical identity must be reasserted for the chemical identity to remain confidential. Does that sound correct?
That's correct. And to give a little background, because it's complex, the chemical identity area. So the difference between assertion of chemical identity at the notice of commencement stage and to go back and substantiate your chemical identity claim in your health and safety study is that the requirements are very different. So for the notice of commencement stage, you talk about, things like, is this, I certify that this information is not already out there in the public, those sorts of things. Whereas for a health and safety study, we go back to the exceptions, the 2 exceptions that are permitted by Congress. And so what a company has to do at that stage to maintain a chemical identity confidentiality claim in that sort of document, they have to explain why, for example, the chemical identity would reveal the process by which they make the chemical. And let me explain that. There actually are plenty of specific chemical names that actually reveal the process. The process is there in the name. And so that's the kind of substantiation that has to happen at that stage. So to say, as I read EPA is saying and ACC is saying, that no problem, they'll just substantiate this at the point where they manufacture the chemical, does not provide the same assurance to the public that chemical identity that should have been reviewed by EPA and denied under the terms of TSCA will be denied. And so, very different contexts.
But are you saying that, let's say there are two companies' notice of commencement, and one of them had a pre-commercialization claim, and the second one didn't. And now, when they both do their notice of commencement, are you saying that one of them is subject to a more onerous requirement for substantiation?
So the issue is not about it's about whether either company may have submitted at the stage where they apply to make a new chemical, submitted information such as health and safety studies. So
it's not that the answer, I think the answer to my question is no.
Is no, yeah. So we're talking,
So
we're interested.
why two companies, they're both making a notice of commencement claim? Like, why punish the one company for having previously made a pre-commercialization? Why not just treat them as apples and apples?
Well, if the company didn't make a pre-commercialization claim, then the chemical identity is now public. And if they didn't have any documents that they submitted with their new chemical application in which they claimed chemical identity secrecy, then it's not an issue.
They can't make a CBI, the company that did not have a pre-commercialization claim, couldn't they make a CBI claim on a new chemical when they commercialize it?
So how it works
That's not
yes, it's so no new chemical may be made in this country until the point when the company submits a new chemical application, then EPA reviews the new chemical application and says, either you're good to go or you're good to go with these restrictions or you're not, right? But in this circumstance, we're talking about companies that are permitted to go ahead and manufacture their chemical. And so what can happen at the new chemical application stage? Well, what does happen is that there's a variety of information, much more information that is required from the companies, such as health and safety studies.
I think I understand that
Okay.
part. What I was confused about, and maybe still am a little bit, is at one point it sounded like you were saying a company will sometimes do a notice of commencement when there was no pre-commercialization claim, but then at other times it sounded like you were saying, no, a company would never do a notice of commencement unless they've already done pre-commercialization.
Meaning a pre-commercialization claim for chemical identity secrecy.
Right.
I think it just is a matter of, well, practically my understanding is that almost all new chemical applications, chemical identities are claimed as confidential by companies. So it's going to be a very rare case where a company didn't have something that they submitted to get their new chemical approved without a claim of chemical identity confidentiality.
So isn't it correct that you have to submit your request for confidentiality at the time that you submit? And this provision just says you don't have to substantiate until later.
So you're asking, do you have to submit your confidentiality claim?
Even if it's pre-commercial, as soon as you submit,
It does not have to
that's
be.
when you have to claim your confidentiality.
You do claim, yes.
Right, because that's what the general
But I think
framework is. But this substantiation doesn't have to happen until later under this provision.
yes, and I mean, I think fundamentally, not that claiming is not important, it very much is. An assertion or certification by the company is important, but where the real meat is where you're required to substantiate, and then EPA is triggered to then have to review that claim. And so the issue is when there's no substantiation, there's no EPA review. And so these claims could be sitting out there invalid.
I guess I have one question about your claim that the EPA changed language throughout that used to be mandatory, like we will disclose to we may disclose. And I guess I'm looking for where in the record they might have acknowledged that they were making a change in their position.
Yes, that they acknowledge that
Because they do
making- yeah.
explain why they've made it may instead of will. But I understand you to be arguing that an agency has to acknowledge a change of policy when they changed their policy, and they never acknowledged they were changing their policy. Is that right?
You know, there are a couple of provisions that EPA changed to will from May that are not challenged here because we pointed them out in the comment period, and EPA sort of said, "You're right. We're going to change it. We're going to change that to will." That comes to mind as an acknowledgement, but I can look to see. That's a good question. I mean, I think our fundamental argument was that, you know, we had these additional sort of Part B practical arguments for why these changes were arbitrary and capricious, and you know that they were additionally arbitrary and capricious because EPA didn't provide reasoned or, you know, any sort of fulsome explanation for these changes.
Okay, thank you.
Are you arguing that when they changed will to may, they failed to acknowledge that they were making a change in policy?
My memory is that for maybe some of the provisions, they said, this is no change. You know, it's consistent. And maybe for others, they did not. I can look at that.
I mean, it seems like just your hesitation to answer the question about, is this your argument, suggests that it's not your argument.
It's not I don't view that as a fundamental basis for that argument. The basis is, you know, you had this way of doing things. You had these regulations. You changed them contrary to the statute, which is our A argument. And you really didn't give
But if we don't agree that it's contrary to the statute and we don't agree that they didn't explain it, you're not arguing that, but you have to acknowledge that you made a change in.
that's not a fundamental part of our argument.
So you're not arguing
I think that they largely acknowledged. Well, I would like to take a look at that, but the fundamental part of our arbitrary and capricious argument is that they changed.
So I'm hearing you saying that you're not arguing that.
That is not the fundamental part of our arbitrary and capricious argument.
Is it any part of your arbitrary and capricious argument?
I will come back if I can find, you know, I'll look in the briefs and let you know on rebuttal, but that is not, you know,
That's fine. Thank you.
central part.
Judge Edwards, do you?
Yeah, I want to make sure I'm understanding your argument on study. If I'm understanding you correct with respect to how we construe study, your basic point is we're talking about pursuant to the statute, the kind of study, not the scope. And there are only two exceptions, and that's it. Can't go beyond that. Your point is very straightforward. The statute is clear. We're talking about kind. If it's statutory words met, then that's it, unless you meet one of two statutory exceptions. That's it. It's a study.
That is a good summary.
Thank you. We'll give you 2 minutes on rebuttal.
Good morning, Your Honors. May it please the court. David Chung on behalf of petitioners American Chemistry Council and American Fuel and Petrochemical Manufacturers. The industry petitioner's case is very straightforward. It's about protecting specific chemical identities, one of the most valuable property interests in the chemical industry. It is not about shielding information on the effects of chemicals on health environment from disclosure. I want to start with some background on some key terms that are going to come up throughout this argument. Specific chemical identity refers to the precise name of a particular chemical substance. It identifies molecular formulas, detailed structural information, and even process information. As my colleague from EDF acknowledged in her argument, the name says it all. Put simply, the identity is the secret recipe. Congress recognized the importance of protecting specific chemical identities from disclosure and memorialized these protections in TSCA. And as EPA acknowledged in its reply brief, if only the original manufacturer knows the specific chemical identity, EPA is required to mask the identity and prevent disclosure so that no other entity, such as a competitor or a private citizen, can know the name of that chemical substance or its chemical structure. Importantly, when EPA masks a specific chemical identity from disclosure, it assigns a random 6-digit identifier known as an accession number. Unlike specific chemical identity, accession numbers are public, and EPA has long explained that these cannot be claimed as confidential. Companies that are seeking to protect their specific chemical identities from disclosure often give the non-confidential accession number of their substance to customers. This is explained in the record, for example, at JA 197. And I'm just going to give you one example of how this plays out in the real world. Imagine a chemical manufacturer in the US makes a unique proprietary binder material that can be mixed with metal oxides and used in solar storage cells in order to increase efficiency. That manufacturer sells the binder material to a company in Japan, which in turn mixes the binder with metal oxides. The Japanese company knows only the accession number of the binder material because the original manufacturer claims the chemical identity as confidential. After the Japanese processor mixes the binder with metal oxides, it then sells that mixture to a solar cell manufacturer back here in the US. This is the third company. The cell manufacturer also knows only the accession number because, again, through the chain of commerce, the confidential chemical identity belongs only to the original manufacturer of the binder material. The importer does have the ability to check EPA's TSCA inventory to confirm that the accession number is listed on the inventory, that this is a valid substance and that it is okay to import the material. So the cell manufacturer does import this mixture to make solar cells, and it is required to report under TSCA as an importer. The only identifying information this solar cell manufacturer has the ability to report is the accession number because it doesn't know the underlying confidential identity. Under EPA's final rule, the solar cell manufacturer's submission nullifies the original manufacturer's confidentiality claim for the specific chemical identity of the binder material. This happens even though no one else in the chain of commerce or within the general public knows the specific identity of the binder. This is the scenario that EPA refers to as the knowledge issue. The final rule's approach to the knowledge issue is contrary to statute, arbitrary and capricious, and just defies common sense.
So even if I agree with you, I'm confused about why knowledge makes a difference here. Because it seems to me that you have a strong argument because this statute says that, I'm looking at C1A, a person seeking to protect from disclosure any information that person submits under this chapter. Person submits. In your scenario, anybody who doesn't know the chemical identity is not submitting that information. They're only submitting the accession number. So they shouldn't have to assert and substantiate any secrecy on that. But I don't know why that turns on knowledge. It just seems that anybody who is not submitting the actual chemical identity should not be able to waive a CBI designation. And so I'm confused about why it is that people who do know the identity can waive the original owner's confidentiality.
So two things. One, you're just as confused as industry was. The industry was scratching its head as to why the report of a non-confidential identifier can undermine the original confidentiality claim. I agree with you, Judge Pan, with your reading of Judge C1A. It doesn't seem like the substantiated requirement even springs into play for somebody who is only reporting.
I'm just confused about, there seems to be some industry understanding though, that if you do know the identity, then you can waive it even if it's not yours. And that just confuses me.
Yeah, so yes, there's no dispute from industry petitioner standpoint that if multiple entities know because they independently arrive at the confidential identity, there's no longer any secret sauce, right? In other words, the original.
But even if you know, but what you submit is the accession number, why should that matter? Like, it seems to me that under the statute, it should depend on what you submit. Because it says what the person submits. And if you're only submitting the accession number and anonymized information about the identity, you should never have to substantiate, even if you know what it is. If you use the accession number, why is it that you would have to do that if you know?
I think the answer to your question is if you do know, you have to claim and assert. You have to assert a claim and substantiate if you expect it to be protected because.
But what if you know, but you only use the accession number?
Then, well, under the final rule, reporting with the accession number without the substantiation of the underlying identity does constitute.
I'm saying, assuming I agree with your reading.
Yep.
why shouldn't it be the case that we would read the statute to say anybody who submits just the accession number can't waive the original CBI determination,
I think that's
whether
how
they
you,
know or not?
I think that's how you should read the statute, is if you're submitting non-confidential information only, that shouldn't jeopardize the underlying claim. And let me remind you that underlying claims are not indefinite, right? They're for 10-year terms under 14E.
Right.
So this is not a scenario where the industry can get together and say, no one report, and because no one has to substantiate. Well, that claim expires by statute
No, I
within 10
understand that.
years.
So basically, though, knowledge should not be a part of this. It should be what you submit is what we should focus on according to the statute.
I think that's a fair reading of the statute, and our focus on knowledge is because of EPA's unreasonable position that reporting with just non-confidential information undermines the original claim. So let me drill down on the statutory claim a little
Can
bit.
I actually ask a fact, I guess a fact question?
Sure.
Follow up to Judge Pan's questions. Are you allowed to submit an accession number if you know the chemical identity?
Well, there are some reporting rules that actually require you to report by accession number.
Okay,
So-
even if you know the chemical identity?
Yes.
Okay.
There-
Then now it all, what you said makes sense and you just,
Yeah, and-
the questions make sense. Okay.
Just to provide a little bit more detail on those, the way those rules are set up, if something is non-confidential, then the direction is you report the specific chemical identity and the specific chemical abstracts registry number. So these are ordinarily confidential, but if it's already public, that's how you're supposed to report. If something is on the confidential side of the inventory, those reporting rules say you report the accession number. And then there's a provision in those rules that says, if you don't know the underlying confidential identity because your supplier won't give it to you, you have to invoke the joint reporting mechanism. And that's
Have to
important.
what? What did you say?
Then you have
To what?
you have to undertake the joint reporting mechanism. You have to invoke the joint reporting mechanism under which you have to show to EPA that you made a request to the original supplier that they provide the confidential information. And that's the provision we discuss in the inventory reset rule on pages 59 and 60 of EPA's brief. That's also the provision that's relevant in what's
How
called
is the agency supposed to be able to distinguish between downstream, so to speak, receivers of the chemical, between those with knowledge and those without?
If the question is who's in or whether the agency has the ability to figure out if you have knowledge or not, EPA has acknowledged that this can be challenging. But the way it has taken the approach in the past is it has.
Now, what do you think the rule says about that now?
What the rule says about that now is EPA is presuming that if you report with accession number, you are in some sort of position to substantiate, because the rule unequivocally says if you claim or if you provide a submission under this rule 703.5 and you fail to substantiate, then EPA will move the confidential identity over to the public side of the inventory without further notice. So it has come in, and contrary to what it has done in some prior rules, now it is saying if anybody reports by accession number and fails to substantiate, that's the end of the matter. It is now a public substance, even though the reporter may or may not have knowledge of the underlying identity. And that's precisely what's so unfair about this final rule, Judge.
And the reporter has no ability to be able to say, I don't have knowledge, I have the accession number, that's it.
Under this rule, it is not an option to say, here's the accession number, but don't waive it because I don't actually know the identity. The default under this rule is final waiver. And to make things clear, in the final rule, EPA acknowledged this is a problem. So I'm looking at JA4. EPA says, we know this problem of lack of knowledge can arise in certain contexts. And it went a step further. It said, here's 3 possible solutions in the response to comments. So I'm looking at JA231. It said, maybe we can relieve some entities of the obligation to report and substantiate. Option 2, maybe we shift that obligation back up to the original supplier, which is the entity that actually has the confidential information. Or the number 3 catch-all was something along the lines of, we'll clarify to you how we will proceed if we determine that the reporting entity does not have knowledge of the identity. The problem is it dangled these solutions and it didn't adopt a single one of them. Instead, it
They said,
finalized.
at least in some circumstances, they would develop, in these knowledge cases, they would develop rules later on.
With respect, Your Honor, that's not good enough, because unless and until they come back to this and fix it in a future
Wait,
rule.
why is that not good enough?
Because right now the exposure is real. They don't deny that the exposure is real and that waiver is the default result under this rule. So the very next time entities begin.
But then what, now I'm completely confused. What does the EPA think they're attending to when they say, we understand there's a problem and we'll address it, not here, but when we see it, we'll have special accommodations to deal with it? Why isn't that good enough?
So two responses. One is that this rule overlays on top of all reporting rules. And this is clear in 703.1. It's clear on JA4. This rule works in tandem with specific reporting rules. And so right now, as we speak, one of the biggest sources of information that EPA gets under TSCA is called the chemical data reporting. That reporting is happening right now through the end of November. This rule stacks on top of the chemical data reporting rule such that anybody who reports under the CDR, as it's known, if it reports with just the accession number and fails to substantiate the underlying identity, that equals waiver because of how the two rules work in tandem.
When does the EPA's special arrangement come into effect in that situation?
Why?
When?
But
When does it come?
the short answer is it doesn't, unless EPA amends this rule or unless it amends the CDR.
They've said, we'll take care of those with special regulations to address the particular situations. They've said that.
They said we may come back to this. And
So that's what your argument is. They haven't really promised to attend to it.
well,
They're saying maybe we will. That's not, certainly not the way I read the record. I thought they understood. I realize their position is trying to have their cake and eat it too, but there certainly is a part of their position which says we'll have special accommodations in situation where knowledge makes it difficult to address the situation, and we'll attend to those when we get to them. In other words, it's not an automatic waiver.
with respect, Your Honor, the way that they've set this up is they've said, we recognize this arises. We may come back to it, and here's ways we may come back to it. But unless and until they do a follow-up rulemaking, either to revise this one or to revise the more specific reporting rules, such as the chemical data reporting rules that were originally promulgated in 2011, unless they fix it through a further rulemaking, there's no assurance that they're going to fix this. And so the second point there is—
Well, but I mean, if a case comes up later and there's claim of waiver and the party argues, this is one of those situations you said you were going to fix, you didn't fix it. So all we had was the accession number. You certainly can't pin a waiver on that alone. We didn't have any knowledge. Wouldn't that person win?
one would hope. The problem is under the final rule and under EPA's longstanding interpretations, it can waive without further notice. The final rule under EPA's interpretation constitutes the notice that regulated entities have in order for them to lodge an appeal of an improper waiver. Under the way the final rule is written, it specifically says identity will be moved over to the public inventory without further notice to the submitter. So in some instances, it may be too late by the time the original claimant learns about this. And part of that is because of how the chemical industry is set up. Original manufacturers don't always have perfect knowledge of everybody down the supply chain. There are ultimate customers that might be 2, 3, however many steps removed that are submitting reports to EPA, and the original manufacturer does not know that that's within their universe of customers. If those people report without the knowledge of the original manufacturer, that results in a waiver. One final point to your question, Judge Edwards. EPA provides one example of the trust us, we'll come back to this approach. And that is the final PFAS reporting rule that was still pending at the time that this rule was finalized. Eventually, the final PFAS reporting rule was finalized with some language that appeared to undertake option 3 that it dangled as a possible fix. And that final rule says, we won't publicize a confidential chemical identity if we determine there was a waiver by an entity that did not know the specific identity. So at first blush, this looks like maybe that solves the problem in the PFAS reporting context. The problem is EPA turned right around and coupled the final rule with reporting guidance to reporting entities that says knowledge of an accession number is essentially the same thing as knowledge of a specific chemical identity. So in other words—
As a general rule, but then they also said in what they've produced here, that in the situations that you and I have been talking about, there would be accommodations. Now, you're annoyed because you don't have the particulars of the accommodations, and I'm trying to think, is that a worthy argument? It's not as if EPA has ignored this as a problem. They understand the problem. and they say there will be an accommodation. I don't know how you can lose that case.
They don't say will be an accommodation. They say we may address this in more specific rules. They don't say we may address this on a chemical by
But I
chemical
mean,
basis.
isn't the essence of what they're saying in this whole knowledge area that we understand there's situations where it would be inane to say there would be a waiver if in fact, in the case that we're now being presented in court, there was no knowledge by the person who could allegedly waive, and that person's going to win. That's not going to be a waiver because the EPA is now acknowledging that's a problem.
Respectfully, Judge Edwards, because that person may not know that their chemical is on the cusp of being waived, that situation, they may not have the ability to fight and try to win. And then secondly, if EPA's final rule is interpreted as a promise that it will fix this, then 703.5 is superfluous. Why promulgate a final rule where the default is waiver without further notice if they promise that they will actually fix this? Again, I would submit they don't come close to saying that they will fix this. They say we may come back to this in a future rulemaking. They never say we will fix this on a claimant by claimant basis, on a chemical by chemical basis. Instead, they say maybe we'll do a rulemaking sometime in the future. And we would submit that that's not good enough.
Quite honestly, I'm not sure why you're worried, because one of the other rules that EPA has here is that even if something should have been raised and it wasn't, they may or may not allow disclosure. So,
Yeah, I see
you
my
like
time is
that
up, but
one. You like that one, don't you?
Well, I'd come back to that in the
Yeah.
intervenor argument. I'll come back to that soon. Thank you, Your Honor.
May it please the court, Philip Dupre on behalf of EPA, and with me at council table is Stephanie Schwartz from EPA's Office of General Counsel. I want to start out by trying to give a little bit of clarification to the issue you just discussed, and that is sort of what accession numbers are. So obviously they're non-confidential identifiers for specific chemical identities. Originally, when a company or importer or manufacturer, whoever would report to EPA, they had to report the specific chemical identity, right? That would, if you knew it, that was confidential information that you knew. Eventually, EPA started to, in some specific rules, allow or require companies to report by accession number as a proxy for that specific chemical identity. EPA's view was that what was being reported was the same. In other words, the chemical identity, not the accession number, which in and of itself is that they don't care about. They care about the chemical identity. So as EPA made this transition in some rules from requiring the specific chemical name under the CAS-RN system to allowing or requiring accession numbers, they treated the submitter's obligations the same with respect to asserting that the fact that chemical identity is in U.S. commerce is confidential business information. And so
they treat the accession number as CBI?
They treat the accession number as a proxy for chemical identity. And where a company submits a chemical identity to EPA, it is required to assert that that chemical identity is CBI.
That obviously creates some problems when the company doesn't know what the actual identity is and only knows the accession number.
Yeah, we're concerned about the downstream.
Correct. And I think here's where I'd like you to, I think the PFAS rule is a great example of where EPA addressed this concern
Can I just ask you, just as a question of statutory interpretation, why isn't it contrary to law for you to adopt this rule that insofar as this downstream person is only using the non-confidential accession number in its submission, that you would require that entity that doesn't know the identity of the chemical identity to have to assert and substantiate in order to keep that confidential. The statute says, this is C1A, a person seeking to protect from disclosure any information that person submits under this chapter shall assert and substantiate.
Mhm.
What is submitted by this downstream person that doesn't know the identity is only the accession number. So why does it have to substantiate and assert the CBI, the chemical identity, that it doesn't even know? It seems to me that that is contrary to law, what you're requiring in this situation.
Mhm. We would disagree and believe that what's being submitted is the specific chemical identity.
But that's just
Through-
a fiction that you've adopted. It's not in the statutory language.
So I think, I mean, simply, we disagree, and I think I want to point
Wait,
to,
add to that, is the downstream entity
Mhm.
submitting that succession number to the agency? They're required to submit it?
in some circumstances, a downstream entity would be submitting an accession number. And I want to point out the PFAS rule because it was,
I know you want to get to the PFAS rule, but
yeah.
I think following up on what Judge Pan just asked, I don't know of a case where we've said the agency has promulgated a rule that is contrary to law, but we're going to deny the petition that challenges it because the EPA has said it might fix it down the road.
Okay.
That seems like a very if it's contrary to law, it's invalid today.
I think it's important to distinguish between this rule and reporting. The CBI rule doesn't require anyone to report anything, right? EPA has a whole other set of rules under TSCA Section 8 that deals with reporting. So they include the PFAS reporting rule, the CDR rule, and some of those rules require reporting by accession numbers, the numbers that we're discussing here. Some of them require reporting by the actual specific chemical identity, the non-confidential CAS-RN number. Okay, so just to even start with, we're not dealing with this in every single reporting rule. It is not.
If I don't have an obligation to report and I'm downstream, right? I don't have an obligation. And I don't seek any protections. Is that waiving confidentiality for the original creator of the chemical?
So I think it's
that's clearly the thing that's bothering all three of us.
yes. So
That is in that situation where I have no obligation to report, I have the accession number, I have no obligation to report anything, I don't. Is my failure to seek protection a waiver of the upstream operators' protection?
if there's no obligation to report, there could not be a waiver because what we're talking about
You
here
have
is.
to report the accession number, but you don't have to report the chemical identity.
No, wait, I heard him saying, in some situations, you do not necessarily as a downstream operator have to report even the succession number. Is that right?
Correct. There are many instances. So
But I think that's not Mr. Chung's concern.
I know what Mr. Chun's concern is, and
No, I know. I want to make sure we're clearing that out. Because that's a really difficult situation. I
So-
have no obligation to report and I could somehow waive the upstream. So you're saying, no, that's not on the table.
Okay.
Right?
so if an entity is not reporting to EPA anything,
Right.
then they can't waive anything because
Okay.
it all has to do with
I got you.
EPA's knowledge, right?
So
So
now imagine the exact scenario that Mr. Chung laid out in some detail, where the downstream company is required to report the accession, but the downstream company, which is subject to a TSCA reporting requirement for the accession number, does not assert and substantiate a confidentiality claim for the specific chemical identity,
Mhm.
for the simple reason that it does not know the specific chemical identity. In
So-
that instance, are there going to be some occasions under the current regime and the current reporting rules in which the EPA will now treat that as a waiver and disclose the chemical identity?
It will start a process that could lead to the disclosure of the chemical identity.
But-
And I also want to clarify.
And the process will disclose absent the EPA
So let me.
changing rules as they currently exist.
So let's imagine there's a manufacturer who has submitted information to EPA, including chemical identity, and claimed that chemical identity is CBI. And EPA has, let's say, approved that claim, right? Now, let's say a year later, an importer submits information via accession number without knowledge and doesn't assert a claim for CBI. For reasons I want to get into later, in particular with the PFAS rule, I think that's unlikely, but conceivable, right? What would happen then is EPA then would have to go back and deny the claims for CBI for that chemical identity for everyone who asserted it. So they would send to the original manufacturer a notice of denial, and that would kick off a process in 2613G, right, where they would be notified of denial and have appeals rights. So that manufacturer would get notice and would have appeal rights within EPA to say that there should not be deemed a waiver because this information is confidential, it is not publicly known, and should be kept confidential. So generally speaking, that's what would happen if
Asserting that the downstream operator didn't have the information
Correct.
that you're now seeking, and so you should not count that as a waiver against us.
correct. Although I think it's important to note that CBI claims are not specific to companies. It's sort of almost like because it's CBI that the chemical is in commerce. So it's not sort of unique to the company, because if anyone knows it's in U.S. commerce, then everyone knows, sort of thing.
And I understand that you're saying the EPA might maybe at some point in the process spare the company with the CBI claim from disclosure, but that will be at best an exception to, and at worst in conflict with the rule you promulgated. I'm going to read one sentence from it. It's, the chemical identity is no longer entitled to confidential treatment and may be published on the public portion of the TSCA inventory. And that's what happens, I think, if a downstream company submits the accession number and doesn't assert and substantiate confidentiality claim for the chemical identity. Again, the chemical identity will then no longer be entitled to confidential treatment, may be published in the public portion of the TSCA inventory. It seems to me that that rule is requiring the EPA to disclose, but the statute prohibits it from disclosing. So it's in conflict with law.
I mean, I would disagree. I mean, because of the may, right? So the may has to be read.
It says they may do something that the statute prohibits.
Well, let me give you an example where the statute clearly wouldn't prohibit. If a company submits information, doesn't claim it as CBI, and no other company had ever claimed that chemical identity is CBI, then yes, they could move it to the public portion of the inventory
I don't see
without.
how that response to Judge Walker's question. Section 2613A provides EPA shall not disclose. You shall not disclose information validly claimed as CBI. It's been validly claimed by company A as CBI.
Yes.
And now this downstream company B the person submits only the accession number. And so then there's C1A that says only the information that person submits needs to be asserted and substantiated to keep it confidential. And they're not asserting the chemical identity. They're just using the accession number. And you're saying that that person who doesn't even have that information would be required to substantiate why that company A's disclosure should remain confidential. There's nothing in 2613A that says that you can do that. It says you shall not disclose. And so I don't see how it is at all consistent with this statute, provisions A and C1A, to do things the way that you're proposing to do them.
I think it's important to look at what the reporting rules actually require. So in some instances, reporting rules do specify how a company should
No, I
claim
understand
information.
that. I'm saying, assuming we're reporting with an accession number, how is it not contrary to law for you to require this downstream company that's only reporting an accession number to have to substantiate the chemical identity? That's not what that person submitted.
Well, in some circumstances, EPA doesn't. And this is the example that was omitted.
Answering my question, I'm saying, how is that consistent with the law to do what you just said? You're just giving me examples of maybe it doesn't happen in this situation or maybe that situation. How is your policy, the rule, what you are proposing, consistent with this statute?
Because the submission to EPA is a proxy for the specific chemical identity.
And what if it's contrary to law for you to deem that a proxy? Because the statutory language doesn't allow you to do that.
We would disagree that the statutory language prohibits EPA from treating accession numbers as proxies for chemical identity.
It says what they submit. If they don't submit the chemical identity, they shouldn't have to substantiate the chemical identity. What in this statute allows you to require somebody who doesn't submit something to substantiate it when it says what the person submits?
They are submitting the specific chemical identity through a proxy.
How are they doing that if they don't even know what it is? And how do they substantiate it when they don't even know what it is? To substantiate it, they have to say what it is. They've done an internet search that it's not in the internet. They don't even know what it is.
So if I could speak to those specific examples.
Please.
So in some instances, in the PFAS reporting rule, for instance, a whole class of article importers is exempt from having to certify or having to submit a claim for CBI or substantiate. So they're carving out a whole class of article importers.
So just because sometimes it doesn't work that way, that doesn't answer the question of how you can ever do it this way. How can you ever require somebody who hasn't submitted a chemical identity to substantiate it when the statute says what they submit? You're saying, well, we consider chemical identity and accession number to be the same thing, but nothing in the statute allows you to do that.
Did you go this route? I'm trying to think what I remember in the briefs. Did you go this route because the agency thought there would be issues in figuring out who really knew and who really didn't?
So certainly that is an issue. And so one of the things, and I think if you look at the joint,
Sorry, please.
if you look at the joint appendix, starting at, I believe, 228 going through 232, you have EPA's fulsome explanation of why it did it. And so one of the issues we have is if you simply said, well, reporting by accession number, you don't have to substantiate or assert anything, you would be clearly overbroad and you'd be carving out from a whole class of reporters who do know the underlying chemical identity.
Why wouldn't you just amend the reporting rules to say, if you know, you have to do what you know, we can't use the accession number, and then they would have to substantiate.
Well, some of the reason why EPA shifted from CAS-RN numbers to allowing accession numbers is for sort of administrative convenience and
I understand that. I'm just saying there's nothing stopping you from dealing with the knowledge issue without being contrary to law with the statute. You can deal with the knowledge issue by saying, if you know, you have to report the chemical identity. And once you report the chemical identity, then yes, the statute does require you to assert and substantiate. But if you're only reporting the accession number, the statute doesn't allow you to require them to assert and substantiate the chemical identity.
I think one of the issues, well, there's two things. I mean, one is I think that would be one of the many options EPA could consider if this issue is remanded back to the agency, right? How do you incorporate that in there? But I also think the agency has concerns that we would want to make sure part of what the Lautenberg amendments did was want to add a little bit extra review by EPA of CBI claims for specific chemical identity. And there may be tension or problems if a company could simply submit, I don't know, in a checkbox rather than go through the full list of substantiation questions wherein they actually knew the underlying chemical identity, right? Where you know there's always a balance between forcing fulsome answers from applicants and administrative convenience, and if simply say, if you just check this box, you don't have to actually substantiate your claim. I think that could be problematic, that EPA would need to look into.
You would deal with that in regulations about reporting, but you don't deal with it within the construct of this statute.
I agree. And what you just said is you deal with it in regulations about reporting, and that's exactly what EPA does. This is not a reporting rule. This is a CBI rule. And so there are examples in the PFAS rule of EPA addressing this with respect to PFAS reporting. There are other rules, for example, the nanoscale technology rule that they mentioned in their reply brief, that does not require reporting by accession number and does require reporting by the non-confidential number. In other words, the issue they raise is not at all applicable in the nanoscale reporting rule that they discuss in their brief.
Why is what I'm about to say not the status quo right now as of the final rule? The statute says there are certain chemical identities that you cannot disclose. The rule says those chemical identities are no longer entitled to confidential treatment when the types of things happen that we've been describing. So far, the regulation is contrary to law. Let's say that will affect 1,000 chemicals. And what I hear you saying with regard to amending reporting requirements in the future and the reporting requirements that you've already amended is don't worry about those 1,000 chemicals that this rule requires the EPA to illegally disclose. For 400 of those, we've already fixed it through a reporting requirement. And for the other 600, we might fix it down the road. The fact that you fixed 400 of the 1,000 doesn't make this rule legal. And the promise that you might fix the illegal rule you've promulgated, fix the effect of the illegal rule you've promulgated for the other 600 down the road, I think is, number one, cold comfort to those companies who probably can't depend on you fixing it through the reporting rules, but also it doesn't change the fact, even if we were assured that you would fix it down the road through reporting requirements, it doesn't change the fact that as of today, when we make our decision to either grant or deny the petition, the rule requires something that's illegal.
I think first I'd say, while I know the numbers were hypothetical, 600 and 400.
It could be 40,000 and 100,000.
I think the closer is we don't even know if this has happened a single time. This is sort of a hypothetical concern, which doesn't mean it should be ignored, and the agency clearly hasn't ignored it. But I would disagree that there are.
Acknowledge that it could happen. The agency acknowledged that this could happen, and you said the way we'll deal with this is in dealing with the reporting.
Absolutely.
So it is not strictly hypothetical for our purposes now, like it can happen.
And that's why the agency has addressed it in reporting rules and continues to do so.
It hasn't fully addressed it.
Well, the issue is, where is the best way to address the effect of where the agency requires reporting by accession numbers?
But isn't that the question only if you're not contrary to law? Like if your rule is contrary to law, it's just contrary to law and you can't do it. You're saying we're allowed to do this and so we can just address this later.
Well,
but I guess if the rule says you're not allowed to do this at all, dealing with it later is not going to solve the fact that you're violating the statute.
I mean, so certainly I'm not saying that the agency can do things contrary to law. Our position is twofold, right? I think the language that you look in 7035, where it says they may move the substance from the confidential to the non-confidential portion of the inventory without further notice is in the context of the overall scheme, right? And so as I gave the example of earlier, if you had a manufacturer submit a CBA claim for specific chemical identity, and a later submitter, even for example, let's just all agree, a later submitter with knowledge, right, knows a specific chemical identity, submits a form, not using accession number, right, with using that specific chemical identity, EPA would then still have to go back and deny that original manufacturer's claim and start a process that would allow appeal. So I think the language should be read better in the sense of, yes, if a company who's the only one that submitted this claim for CPI waives the claim, the agency doesn't have to wait to move it from the confidential to the non-confidential portion of the inventory. And I think it's also important to note that I don't think there's anything improper about EPA treating accession numbers as proxies for specific chemical identity, because what they're requiring to report is specific chemical identities.
Why would a downstream operator or whatever it is be required to submit the accession number? In what circumstance?
So the example is, so just in the PFAS reporting rule, for example, right, we want to know what articles are being imported into the US that contain PFAS. And so, for instance, maybe you put PFAS on like a raincoat as part of the coating process. And so EPA wants notice of what's coming into the country. Now, again, EPA carved out article importers from having to
Wait,
substantiate.
don't go there yet.
Okay.
Does that operator who is required to report the accession number, must they and are they able to substantiate as required by law? Are they in a position, if they don't know, they don't have the information?
So in this instance, they cannot, EPA does not even give them the chance to substantiate. They simply take article importers out of the class of reporters that are even able to submit a claim for confidentiality, or would have that claim reviewed, or would have to substantiate that claim.
No, wait, I may have the factual scenario wrong. If I'm a downstreamer and I'm required, you say I'm in a situation where I have to report the accession number.
Mhm.
I have to substantiate?
In general, right? So there are specific reporting rules that do not allow you to use accession numbers, and there's specific reporting rules that exempt you from having to assert a CBI
Am I
claim.
going to be able to meet the substantiation requirement if I don't know the chemical?
So in some instances, you would not be able to fully substantiate the claim. However, what EPA has done under both the TSCA inventory rule and the chemical data reporting rule has suggested that entities substantiate as best they could. And so EPA is able to look at, if someone submits information that says, I know this is confidential, I just don't, and I've been told, and that's all I've been told, right? That may be enough within the process to prevent any sort of waiver where EPA looks at the issue. So I think.
What are the incentives of the downstream user to try to protect CBI that is not their chemical?
Well, I think the incentives of the user are the chain of contract between the original manufacturer. And I think this is also important, is that EPA has always said that there is an obligation on, the original entity that makes a substance to take measures to ensure it's treated as confidential. And so that would include either its contracts with downstream entities. It has to protect it through their business channels.
But what if, in the scenario that Mr. Chung posited, he said there's company A that goes to company B that goes to company C. Company C is not in privity with company A, which has the interest in keeping this confidential. So what are the incentives of company C to keep this confidential? And do they have a perverse incentive? Maybe they want it to be public so they don't have to pay for it or something. Maybe they want it revealed. Does that happen?
I don't think there's any perverse incentives. I think,
You don't think that competitor has an incentive to have its competitors' confidential information disclosed to the public so that it can
Well,
then use the confidential information?
okay, so
You don't think Microsoft has an incentive for Intel's confidential information to be made public?
So CBI for specific chemical identities, unlike other claims, right? And so let's say two competitors, right? Both have CBI claims for specific chemical identity. They use the same chemical, right? But it is secret that to the public that chemical is used in US commerce, right? In that case, the two competitors are aligned.
That's not Mr. Chung's hypothetical. I don't think it's Judge Pan's question. At the very least, it's not my question.
Okay, so
I'm
what?
talking about two companies. But let's say they're chemical companies. Let's just call them Apple and Microsoft.
Okay,
And they're competitors.
yeah,
Apple has invented the chemical and it knows the CBI. Microsoft uses it, but it only knows the accession number. It seems like Microsoft does have an incentive for Apple's CBI to become public so that Microsoft can use it
I think
for free. They're using it
Well-
now by contract.
they're using it now by contract. I mean, the part of what would be an issue here. So, right, I guess to be clear, in that example you give, so maybe it would be in Microsoft's benefit to know the actual chemical identity. But if it does that, everyone else in the world will know the chemical identity too. So Microsoft wouldn't just be getting the information for itself, it would be getting the information for everyone. So then, I don't know, Dell and Intel can come in here and make that product too, whereas beforehand, only they had that chemical through Microsoft. So I don't think the incentives are clear cut one way or the other. You know, whether so I just don't think they're clear cut one way or
Can
the
I
other.
go? Oh, no. Can I go to what I think you were saying was the inspiration for the final rule as promulgated? And that is, I think maybe you were saying EPA fears that companies with knowledge of the chemical identity will illegally report with only an accession number.
Or
Is that at least one concern?
that is one of the things.
But then instead of requiring the companies to report with the chemical identity when they know the chemical identity, the EPA has just decided to flip all the chemical identities to the public side of the ledger and then place the burden on upstream manufacturers to go challenge the action. Is that sort of your?
I think I would phrase it a little differently, but I think the default would be, right, that when EPA gets information requesting specific chemical identity, it's fair for it to assume that the entity submitting that information has knowledge, right? And that's sort of a general proposition, and they make changes in specific reporting rules where that may be unlikely to be the case, right? And so they address those rules. But I think that general proposition is where EPA comes down. And I do just want to say, I mean, if
I think they're coming out there because I think the agency is saying it would be, and I'm sympathetic with this, and I'm really struggling with this question. How would they possibly manage a regime in which the rule was trying to figure out who did and did not have knowledge?
I think that's
And
a great.
I mean, that struck me initially. I don't think that answers all the concerns we're raising, which I think are substantial too. But I certainly can see the agency saying, what do you mean we have to have a with knowledge or not with knowledge rule, and how are we going to test that? Many people come in and say, we don't have the knowledge. And so therefore, the accession number's it, nothing's waived, and we go on. And the agency is saying, oh no, we're going to run into all kinds of problems there. But the other side of it is what we've been raising with you. There are terrible problems here because you're putting the upstream person in a real box, having done nothing wrong, having substantiated, having reported, giving the agency what it wants, and now can have all that waived because someone downstream may or may not have had knowledge.
I think what you've picked up on are the issues raised by sort of addressing this so-called knowledge issue, whatever you say, impact a lot of things, right? So if the court were to find that the agency erred here, I think it would be prudent to let the agency address this issue in the first instance. And give the agency flexibility on how to craft a rule that takes into account these competing concerns.
In a related matter, before we run out of time,
Yes.
I'll ask another question. This is the flip side, which I was teasing your opposing counsel about. In your regs, in the case of any unsubstantiated claim, EPA will construe this as a waiver of the claim and may make the information public without any further notice to the server. Where's the may coming from? Isn't there an obligation for this information? Now, the statute's a little tricky on this. I understand it is not entirely clear.
Yeah.
But I thought if the rules hadn't been satisfied and a claim has not been substantiated, it's public.
So
And the agency has no discretion to keep it private.
we agree that ultimately, if an agency is not, if a claim is not substantiated and upheld by the agency, it will be denied. The specific example or the specific aspect that rule is talking about is where the agency identifies a deficiency in a CBI submission. Usually they give 10 days to correct.
I'm not talking about the delay. This language is written broadly enough as if to say, forget the time arrangements under the regs and statute. This is where we have concluded this is not a substantiated claim, but we're still not going to disclose. That's what the way this language reads.
Well, I think there's a distinction between denial and disclosure. So in some instances, if you submit a document to EPA and claim part of that is CBI, and EPA denies the CBI claim, it doesn't necessarily put that document up on its website. It just puts that document in the pile of documents that are subject to disclosure if appropriate, if there's a FOIA, if there's a reason to disclose that document, right?
So you're putting it in the hands of the public. If someone in the public has reason to know this particular issue.
Correct. I mean, in general.
Well, how are they supposed to know? How is the public supposed to know?
Well, I think
In other words, you're
much
saying
of this
it's a
information.
FOIA claim.
So
That isn't the way I read the statute. I thought if it was not substantiated, I thought it got posted.
So much information does get posted, right? And so there's no question about that. My more general point was, there's no affirmative obligation that everything that comes into EPA be publicly disclosed, right? Or posted on a website. And so some submissions, if the CBI claim is denied, and it goes through the process of, the submitters have a right to appeal, and it would be posted on a website, then it would be posted without any redactions for CBI. Yes.
Yeah, I'm not sure you're answering because it still looks like there are a couple of different categories here, found to be non-confidential or unsubstantiated. They may be slightly different. But in either event, what you're saying is we may disclose. And I don't know where you're getting that under the statute.
I think that disclosure is a little different than treating something as CBI. And so certain things must be disclosed, and EPA will disclose those. And certain things sort of may be disclosed as appropriate under other laws and regulations.
Along these lines, there's a claim by EDF about how you've replaced previous language that was definitive, like we will disclose certain things, with equivocal language that you may disclose certain things.
Right.
And we do have doctrine that an agency can change a policy, but it must display awareness that it is changing its position and show that there are good reasons for the new policy. Where exactly in the response for comments did EPA acknowledge it was replacing the definitive will language with equivocal may language, recognizing this change of policy?
So I think EPA, and without knowing exactly what regulations you're referring to, I think in general, EPA's approach to where it changes will from may flows from the new requirements of the 2016 amendments and how it fits into the statutory scheme. And so I don't think there's any clear example of a reversal because we just have a different scheme here under the 2016 Loudenberg amendments. And so it's
But
a
you
little.
were never required to disclose anything that wasn't confidential, but you've now replaced your will language with may language. One example is 40 CFR 716.55. Now you're saying, instead of saying will, we're going to replace that with 703.5's equivocal may be made available. I guess it's just an agent, you're supposed to acknowledge that there's a change here. Here's why.
And Your Honor, I'm unfortunately at a loss for those specific regulations off the top of my head. I think we did explain why the regulations proposed and adopted by EPA were appropriate. And I think we also explained that to the extent there were changes, they were a result of sort of statutory changes. And it wasn't, I don't think there was any sort of clear-cut reversal of comparing apples to apples. EPA used to do things one way, and now it's doing something the opposite.
That's not a change in policy when before you said we will disclose and now you're saying we may disclose. That's not a change in your opinion?
And Your Honor, if you can.
So
I mean,
you used to say if no claim of confidentiality accompanies a document at the time it is submitted, the document will be placed in an open file available to the public. That's 40 CFR 716.55C.
yes.
And now in 40 CFR 703.5, you say, if no such claim accompanies the submission, EPA will not recognize a confidentiality claim and the information in or referred to in that submission may be made available to the public. Isn't that a change? Don't you have to acknowledge it's a change and why you're making it?
So I don't think it is I'm sorry, was that 711-15B3 you were referring to?
No, 716.55C, which was repealed. And then you added 703.5, which says may
Mm-hmm.
be made available.
Your Honor, I apologize. I'm just at a loss finding this in my notes here. And so it's tough for me to compare these specific provisions. I would just
Are you
say.
just aware of anywhere in the record where the agency acknowledged this change? Will to may? Because it's not just that one, I think. There were a number of things that were repealed that said will, replaced with this general.
Yeah, I mean, I think, EPA did address these changes in the record and explain why it chose the language they did. If you're asking me where did they address this change in 716, I mean, I would, we discussed that in our brief starting at page 45. Again, And I would say that to the extent that the language is different in 703.5 with other provisions, again, we believe that is the language required by the statute, and thus fits with the statute. And as I believe was pointed out in, there's a good case cited in the intervener's briefs that, you know, the change in statute itself is a sufficient justification to change position to the extent there is a change.
And is that a argument that EPA is making for the first time in its red brief, or is that an argument that EPA made?
I think that's an argument. I think it's an argument we made, although we didn't find a good case to support it, so we supported it without a case.
It's an argument that
EPA made.
on appeal. I mean,
Correct.
in defense of the petition,
Correct.
and that EPA did not make before the rule was challenged by EDF's petition.
EPA explained why they made the changes they did and adopted the language they did in 703.5. Now, whether or not EPA was required to say, as a matter of law, we're entitled to change or alter our regulatory language because the statute has changed. I don't know if they specifically said that, but we certainly in our briefs have argued that a change in statute is justification itself to change a regulation.
I understand that. Nothing more questions? Then, thank you.
Thank you.
I think Mr. Chung will, as an intervener, be able to have 5 minutes to respond to EDF's petition. And then I think you also are going to get 2 minutes of rebuttal to defend your petition. I think it makes sense for
I'll just stay up.
you to stay up.
If that's okay with.
So I guess it'll be a
my
total of
counsel.
7 minutes.
Thank you, Judge Welker. I just want to be very brief on the intervener side arguments, unless the panel has questions on any of the specifics. But I think to your question about whether EPA was acknowledging the change from May or from will to may, I believe the answer is set forth at JA 254, where EPA offers the explanation that the change from may deny to will deny was in fact intentional. And it was not.
Was in fact what?
Was an intentional change in the regulation. And it was not because EPA made it very clear that this was not to suggest that disclosures in doubt if information is not confidential. The change from will deny to may deny was simply made to increase flexibility over the timing of the disclosure. So EPA says, balancing the interest in the statute, it says, it may be possible that a finding of a deficient CBI claim can in fact be overcome by the claimant, such as if EPA erroneously found that the submitter failed to substantiate. So it's not, again, the key point here is that they recognize the change, but they were not suggesting that they're going to withhold non-confidential information. They're saying disclosure is not in doubt, it's just a matter of when, and we need to be able to give claimants the opportunity to correct deficiencies in the event.
So you think the language, EPA notes that the language employed was intentional?
Yes.
Is enough to acknowledge that they're changing?
We would submit that does respond to the concerns that it looks like EPA has arrogated to itself the authority to withhold information that's not confidential. And EPA has, although, you know, in a short paragraph, it has addressed that concern to say, we're not trying to hide non-confidential information. We're just controlling the timing.
What would be the consequences to the industry if we were to remand for better clarification of the EPA's use of the word will?
I think industry would be fine with that. ACC as the intervener would be fine with a remand for a more robust explanation.
What about, let's say we were to grant the petition on the first issue with regard to the study. what are the consequences there to the industry?
Thank you, Judge Walker. I will address then some of the specifics about the health and safety argument. Our view is that both to Judge Pan's questions about Skidmore deference, as well as the statutory emphasis on information about effects, as opposed to everything that's contained within the report document. Our argument is aligned with EPA that EDF's whole document or approach, whole document or whole report approach is in fact flawed. The reliance on the language in the text at the end of paragraph B2 is misplaced. If those were the only protections for information contained with a health and safety study, that would completely gut the protections that are very clear in the statute for specific chemical identity. There are, in fact, studies out there where specific chemical identity is in the text of the study. And if EDF was correct that the only the only carve out to the non-disclosure, the non-confidentiality protections for health and safety studies were the two narrow instances at the end of the B2, then that would render protections for chemical identity superfluous. Also relevant to your question about Skidmore, we think NLRB versus Bell Aerospace, which was cited in our brief, presents, this is a similar scenario here in this case, where the agency's longstanding interpretation and Congress's acknowledgement of that interpretation and its deliberate refusal to override it presents persuasive evidence that the agency got it right and that the agency has adopted the interpretation that Congress intended. The NLRB versus Bell Aerospace decision goes so far as to say that that interpretation that has remained consistent is entitled to great weight. And that is obviously a pre-Chevron case and fits neatly within the Skidmore framework.
The problem is the statute refers to study kind, not talking about the provision. We're talking about the particular scope. And there are only two exceptions in that provision. Now, whether or not there is a carve out by reference to a different statutory provision is a different issue. But the study is what is required. It seems clear to me, I understand that we may not be in agreement here. It seems clear to me what we're talking about is study and the two exceptions. That's it in the statutory provision that we're talking about. There are other carve outs that make this a mixed document because the other carve outs from another provision in the statute are absolutely clear. That's a different issue.
Our argument is aligned with EPA's here that the term study does not unambiguously encompass the entire report or the entire document. Because it's a nuanced
A study is a study. You know, if the 40-page study, the study is the 40 pages. That's the study.
But not.
And the statute says there are two things that we're carving out, and that's it. Only two things.
I think if you read that to only cover those two things, then again, you would render the protections for chemical identity superfluous.
Where? In another provision of the statute?
In a neighboring provision, correct. And
if there is another provision in the statute that would require a redaction in a study that is otherwise disclosable, so what? That has nothing to do with the meaning of this provision. I don't see how you get to watering down this provision. It's very clear. It includes any study of the sort that they describe, and it is the kind of study that we're talking about, not the scope. Scope is dealt with twice. There are two exceptions. That's it. That's the only time that this statutory provision deals with scope. And if there are other provisions where a party might be able to argue, but wait, there's a redaction by virtue of another provision in the statute, that's a different question.
Agreed, but I think we have to go back to EPA's arguments that, and Judge Pan's line of questioning, that study, the definition of health and safety study, when it refers to including underlying information, all of that points in the direction of information relevant to evaluating
there's
effects.
so many cases that I've seen over the years, including is not a limitation, including this and among all other things in the study.
Agree, but there are also cases that act as a counterweight, that when a statutory definition lists a bunch of information.
But the problem for you is Congress listed the two exceptions. So including covers anything that meets the kind definition. The two exceptions go to scope. And there are only two exceptions that go to scope.
I respectfully disagree.
I mean, the argument on including, I was really kind of surprised to see it because I don't see how it gets you anywhere.
Well, well, one final point, as a practical matter, I'm not sure there's a material difference between redacting information that doesn't seem to be in dispute, that redaction of specific chemical identity is appropriate from a health and
For
safety
me,
study.
the issue is to whether or not there's another provision in the statute that will require redaction, it's like whatever, that has nothing to do with this issue.
Well, I think you have to look at the overarching command of Section 14, which is that confidential information shall not be disclosed. And so,
And if that means in a study that is otherwise covered, we may have to have a redaction because there's another provision, that's a different issue.
well, and that's our only point, is
Okay.
like chemical
I was
identity.
reading you to say that the provision itself, which deals with kind, except for only two provisions that deal with scope, itself says what you're saying. It's not what it says.
No, I think our argument is that EPA's interpretation, which has been longstanding, is a consistent balancing of the relevant statutory concerns.
Okay.
If I may have just a quick couple of minutes on the rebuttal points for the knowledge issue. So the first is EPA's only response to your questions about whether there's a clear-cut statutory violation is the proxy argument. And Judge Pan, you're correct to describe that proxy argument as a fiction. Logically, it just doesn't make sense. The bottom line is if you don't know the specific chemical identity, you are not in a position to answer any of the substantiation questions, and you're not trying to protect anything confidential. So a waiver based on a lack of knowledge cannot be authorized by statute. The second point is EPA's arguments that the final rule isn't itself a reporting rule and that it will fix the problem elsewhere. Judge Walker, your response to that or your reaction was spot on. Fixing this in a few hundred scenarios and ignoring it in the remaining few hundred does not cure the statutory violation. Third, regarding the questions about policy concerns, one concern is indeed that there might be perverse incentives by downstream entities. This was your Microsoft hypothetical. This is raised at JA 176. This is in fact a legitimate concern that a downstream entity might purposely trigger a waiver to improve their commercial situation, whether it's to obtain alternatives to a product or whether to generate more competition and drive the price down. These are real concerns that, again, make it illogical to shift or to provide that a waiver by
But you
anybody.
agreed, I think, in your first time at the lectern that the agency's got a real issue when it comes to figuring out who does and does not have knowledge. That's not right.
So
So if we were to send it back, they really should have a shot to try and think this through. I don't know what the answer is. You're not offering any. You're just saying the way it looks now.
well, I think Judge Walker's questioning about fixing it only in a few hundred scenarios and his emphasis on the statute, on the regulatory text is the answer. 703 is unequivocal. EPA will not recognize a confidentiality claim. EPA may move that information over to the public side of the inventory without further notice. Without a rulemaking that fixes other reporting rules like the chemical data reporting rule or any other reporting obligation, this is hanging out there as the default rule. The default is waiver. And to one policy, or I guess to one suggestion from my colleague at DOJ about possible fixes, I think latching onto your question, Judge Pan, I think the suggestion to make a downstream entity certify that they lack knowledge in order to check we're not submitting any CBI so we don't have to substantiate box is a reasonable middle ground, right? And you can make that certification subject to penalties for false certification such that a downstream customer cannot just say, we're not going to submit CBI. And that would be a good middle ground. What's not a good middle ground is to ignore the statutory command to protect confidential identity and say, we're going to presume waiver and maybe we'll fix it.
Mr. Chung, thank you. We will give Ms. Lisco 2 minutes.
EPA said that there is a distinction between denial of a claim and disclosure. There absolutely is. And the distinction is huge for the public. It's everything. The fact that EPA denies a confidentiality claim means nothing to the public when it doesn't get the documents. And I think I heard counsel for EPA say, in the case where they deny a claim of confidentiality per TSCA, they just put that document in a pile of documents. Again, the public benefits not at all from such a practice. Also, counsel said that Lautenberg, the 2016 amendments to TSCA, added a little more review of CBI claims. I would call that a major understatement. Section 142613 was majorly overhauled. It was basically a tiny little part of TSCA before. It basically had the health and safety study exception and, kind of the framework, and that's it. Lautenberg added all of the process that the companies have to go through, that EPA has to go through, all to the end of making sure that confidentiality claims are not are made properly and are reviewed by EPA. And that this court has said that the words of the statute should be read in context, and the problem Congress sought to solve should be taken into account. That was quoted in AHA versus Azar 983 F3rd 528. And the problem Congress sought to solve with its major overhaul of 2613 of TSCA in 2016 was that the public should get information that that is non-confidential.
Before you run out of time, Judge Pan had asked you if there was, I guess, part of your brief, I think, or I'll ask it. Is there a part of your brief for this court where you make the argument that we should grant your petition on the may-will issue, the may/will issue? Because EPA did not acknowledge in the record that it was making a change in policy, and it didn't explain why it was making a change in policy.
Well, I would agree with Judge Pan's interpretation of what happened there with 40 CFR 716.55 and then the change. And looking at it now, I see, no, the acknowledgement was not at all.
On page 14 of your opening, I'm sorry, page 42 of your opening brief, you said here EPA has neither acknowledged nor adequately explained the changes.
Yes, and I agree with that still. And also, I believe we made an argument in terms of EPA's changes to the regulations on chemical identity substantiation. There was one where EPA said, and it was for 703.5, I believe. They said, we didn't change that. But in fact, the regulations used to require, there was two regulations, you could read them together, and they required substantiation, reasserting of a claim and substantiation of a chemical ID.
If we agree with you on your third issue, the will versus may issue, and if we agree with you for the reasons that we've just been discussing for the past minute or two, would you suggest that we vacate and remand that part, or would you suggest that we remand that part without vacater?
For all of our claims, all of the provisions we challenge, we ask that they be vacated.
Okay.
Thank you.
Thank you. Let's submit it.
This honorable court has been adjourned Tuesday, December 26th at 9:30 a.m.